Good morning. Happy Monday. Let's talk about the district court decision. Oh, there's slow children here. You shouldn't make fun of children just because they're slow. Let's talk about the district court decision for Porat v. Lincoln Towers. There was, in Porat v. Lincoln Towers, the basic facts are a guy, a recent immigrant from Israel, although I don't know why they have to call him as such, was filming the Lincoln Towers in New York. Second Circuit is New York. The security guards didn't like him doing that. He said, "You can't stop me," and then he proceeded to enter the courtyard of the Lincoln Towers, private property, and continued to film. The security guards arrested him, called the police. Police came, issued him a ticket. Now you could probably imagine why they issued him a ticket. It's for trespass. Cameras don't grant you the right to trespass. The security guards never show up on the ticket. You do need the complainant to show up on that, apparently, in New York. So the charges were dismissed. And so he got a ticket for trespass, but was never convicted of trespass. So he sued. And of course, he sued under 1983 against the cops for chilling his speech. Now, as you can imagine, that's a pretty weak case. Cops didn't care about his speech. They cared he was trespassing. There was a complainant saying that it was private property and that he was trespassing on private property. So the cops issued a ticket and said, "Enjoy, go to court, figure this out." Now, as luck would have it, Mr. Porat was not done with the Lincoln Towers. He went back, apparently multiple times, to film the Lincoln Towers more. If you're claiming that your free speech is being chilled, it doesn't help you much if you keep going back to film. Now, in his complaint, Mr. Porat stated that he was filming for personal reasons, and he never used any facts to allege that he would be communicating these pictures to anyone for any reason. In order to prevail on a 1983 lawsuit for having your free speech chilled, the court correctly stated that you have to prove that you are communicating an idea, that that the officers interfered with you, that the state, not the security guards, but the state, the government actor, somebody under color of law, interfered with your ability to speak, and that they did so motivated by your speech, and that as a result, your speech was chilled. And you have to allege facts. You have to allege facts that prove those three things, or that could, if shown to be true, prove those three things in order to survive a motion to dismiss. He did not allege sufficient facts for any one of those three categories. For category number one, he said that he was filming for his own personal use. There was no intent to communicate those pictures. Now, for those of you who think you have to do something special, you really don't. You just have to allege facts. I was going to put this up on my YouTube channel. Okay, done. You've got a message and someone to communicate it to, right? And if you don't think you have a message, just remember that nude dancing is a message, and the dancers are communicating it to the people stuffing dollar bills in their G-strings. I guess if they're nude, they wouldn't have a G-string, but you get the point. Anyway, so it was a failure to allege that. Now, this is Second Circuit, and you see this in Second Circuit. Hello, Kitty. Don't play with the kitty. This appears to be a Second Circuit thing, and it appears to be revolving around this particular Porat v. Lincoln Towers, that photography with nothing more is not speech. And I do agree with that to a point. Just standing there snapping pictures of someone, if it's for the purpose to annoy them, well, then that's conduct, I think. But, you know, what do I know? So he failed on that aspect because he didn't allege facts sufficient to show that he would ever be communicating that idea. As far as the actions of the state, well, he couldn't do a 1983 lawsuit against the security guards because they weren't acting under color of law. So it has to be against the police. And the police, he didn't allege anything saying that they made the arrest to suppress his speech. He didn't allege any facts sufficient to show that. And you can't just state, well, they did it to, he didn't even state, but you can't just state that they did it to chill his speech, that they did it because of his speech. You can't just say it. You have to actually allege facts sufficient to at least infer it from the facts. That cat's crying. Meow and wants his honey. Anyway. So he failed on the second aspect. And the court found that the cops were motivated by the trespass. They weren't there for the speech. There's no evidence to show that they were there for the speech. There's no allegation of any facts sufficient to show they were there because of the speech. They were there because his dumbass was on private property. And the security guards called the police. And finally, he would have to allege facts sufficient to show that as a result of the actions by the state, that his free speech was chilled. And yet he went back. He claims that he went back multiple times to take more pictures. Well, that doesn't show that your speech was chilled, does it? It doesn't appear that he was scared of any retaliation by the government. It doesn't appear that his free speech was actually chilled. So on all three counts, he fails. And so the district court decision upholding the lower court's decision, not specifying anything on it, doesn't really give us any insight as to whether that first failure is going to be upheld in the future, if it ever gets challenged. And you have to remember that all we have so far, Schloss v. Lewis was a district court case from the Second Circuit, and Porat v. Lincoln Towers is a district court case from the Second Circuit. We don't have any actual circuit court decisions, which at least in the Second Circuit would be precedent to really base our understanding on. So I'm not saying that your photography doesn't have to have any communicative intent. I would, however, argue, and I found a case on this a long time ago, and I don't remember the case. There is a case out there somewhere that says basically along the lines of photography is a little bit different, because when you're taking a picture of something, you may not realize the communicative value of it at the time you take it. And so photography is a little bit special. You snap a snapshot at a resort in Mexico just to commemorate your vacation down there, and then it turns out years later that you got a picture of a famous person or something along those lines. Or upon developing the film later, you realize that there's a UFO in the shot or something. And that was basically the holding of this case that I don't remember. Now, am I going to spend hours and hours researching, trying to find this case? Probably not. You could believe me or you could not believe me. But at this point, that's really all you can do. Or you could research it yourself. And if you find it, let me know, because it was a pretty interesting case. So, or at least it was a pretty useful case from my perspective of wanting to establish and protect free speech. Speaking of which, someone posted on my comment section, about Eric Brandt threatening or telling people they should kill the police. That is free speech, and if you expect me to get outraged over that, I think it's retarded. But seditious language has also been protected under the First Amendment. As long as he's not inciting any immediate violence, he should have the right to speak his mind on that. Even if, we've got to remember, the First Amendment is there to protect offensive speech that you find offensive, because it protects the speech that you make that offends other people. So keep that in mind. Just because he's saying stupid things like that. Now his language might violate YouTube's TOS, and I don't know about that. My dog got distracted by a car that's slow creeping and he banged his head against the trailer. Anyway, might be against YouTube's TOS, but don't expect me to champion any calls to censor people. You can fuck off with that nonsense. Free speech. Thanks for watching. Have a great day.